Okay, guys, here we are for lecture number 2. I'm at my office today. I will try and provide some more interesting backgrounds as time goes on. I'm in my barren government office. So, we're talking about contracts. And remember, the 4 elements of a valid contract are agreement, consideration, capacity, and legality. You'll definitely have to memorize those. Here they are, so you guys can write them down: agreement, consideration, capacity, and legality. We spent the last lecture talking about how we get to an agreement through offer and acceptance. And I touched on 2 of the 3 elements of what makes a valid offer. We talked about a serious intent to be bound. We talked about definite terms, but I forgot to talk about communication of offers. So we'll go back and clean that up right now. Again, the 3 elements of a valid offer are a serious intent to be bound by the offer, definite terms, and the one we didn't talk about, communication of the offer. Obviously, an offer cannot be accepted if it hasn't been communicated to anyone. So, the offeror has to communicate that offer to the offeree. Now, that's typically not a big problem when we look at offer and acceptance, because offers that aren't communicated, that doesn't really happen all that often that I'm aware of. But there is one example of where an offer perhaps is not communicated that I'll give you guys to illustrate the point. So, let's assume that I've lost my cat. I love my cat. I want to get it back. And so, like most people who lose an animal, we put out a reward, right? I post flyers or I post on social media, hey, $500 reward for the safe return of my cat, no questions asked. I bombard the radio and wherever I can with, hey, $500 reward for the safe return of my cat. So, guy finds my cat, brings it back to me, drops off the cat, hasn't seen any of the flyers, hasn't heard any of this business of their reward being offered for the safe return of my cat. And after he drops the cat off, he walks down the street and he sees one of my flyers and he says, oh, there's a $500 reward. I just returned the cat. So he comes back to my house and he says, hey, I want the $500 that you're offering for the reward. I brought your cat back. But because he never saw the flyers, because he never saw what amounted to an offer, because posting a reward that says, if you return my cat, sorry, my phone's ringing. If you return my cat, I will give you $500. Now, that's an offer out there that anybody can accept. Now, because of the way the offer is worded, they can only accept it by actually performing. In other words, bringing me the cat back. And as long as they know of that offer and bring the cat back, they're entitled to the $500. But the example I just gave you was that the gentleman who returned my cat didn't know anything about the offer. And so because that offer was not communicated to him, and he did not return the cat based upon the belief or the expectation that he was going to receive the $500, technically he's not entitled to the reward under contract principles. Now, obviously, I think I would have a moral obligation to give him the $500, but we don't have an enforceable contract because you cannot accept an offer that you don't know about. So those are the last of the 3 requirements for a valid offer, being communication of the offer. Okay, so I want to move on to the next element of every contract, consideration, and we spent some time talking about that in the last lecture. Remember, consideration can be, when we typically think of consideration, we think of somebody's paying somebody for something else, and that's typically the case. But remember, consideration can be agreeing to do something, agreeing not to do something, providing money, And courts, again, don't look at whether or not it's a good deal. They don't look at adequacy of consideration. there are two problem areas with regard to consideration that I want to go over with you guys. The first is adequacy of consideration, and we already covered that. The next is past consideration. Now, this gets a little bit tricky. Remember, consideration, quid pro quo, something for something, a bargained for exchange. Let me give you guys an example. I'm walking around campus and I see Colin get in a horrible car accident. And his car is overturned and there's a fire in the back of the car and it's spreading towards Colin. So I am able to approach the car and pull Colin out at the last minute, saving his life and getting him out of the car. He's very grateful for that. So he looks at me after I get him out and he's okay. And he says, man, thank you for saving me. I'm going to give you $5,000 because I really appreciate it. Well, a couple weeks go by and Colin hasn't given me the $5,000. So I call him up and I say, hey, Colin, remember you promised to give me that $5,000 because I pulled you out of your burning car and saved your life. I mean, the least you could do is give me $5,000. Colin, having studied his contracts and business law, says, I'm sorry, Richie, but that's past consideration, and I'm not going to pay you. And Colin would be right. So here's the way we need to look at this. Was there good consideration for Colin's promise to pay me the $5,000? And the answer is no. Now, why is that? And the answer is because he offered to give or promised to give me the $5,000 after I'd already pulled him out of the car. In other words, I didn't pull him out of the car in anticipation of or in exchange for the $5,000. The promise to pay me the $5,000 occurred after I'd already taken the action to save his life. So therefore, it's past consideration and not good consideration. Can't think of another example of, put it this way. Your rich uncle tells you after you get a 4.0 grade point average this semester, hey, I'm super proud of you for getting a 4.0 grade point average. I'm going to give you $100,000. And then he never pays. And the question becomes, is he contractually obligated to pay you that money? And again, for the same reasons I just talked about, the answer is no. Because I didn't get a 4.0 in exchange for him paying me $100,000. If we change those examples, we can get rid of the past consideration and have good consideration. So if under the Colin example of saving him from the car, I see him in the car is burning up, the flames are rapidly approaching him, and I say, or Colin says, hey, pull me out of here and I'll give you $5,000. And I say, I accept your offer. And I pull him out of the car. Now I've pulled him out of the car in exchange for or in consideration of him paying me the money. Now, with that example, there's a question of duress, and so that might not be a contract. But as far as a good illustration of past consideration, it's perfectly appropriate. With regard to the rich uncle example, if the uncle had said, hey, I'll give you $100,000 if you get a 4.0 your last semester in college, and then you get that 4.0 your last semester in college, that would be a perfectly valid contract supported by good and valuable consideration because there is an exchange. He's not telling me after the fact, hey, good job, I'll give you some money. He's telling me, if you do this, get a 4.0, I will do something else. In this case, give you $100,000 is what I think I said. So we don't have the past consideration problems like we did under the initial examples. So watch out for past consideration. Again, you typically see those situations arise when somebody promises to do something based upon something that's already happened. You have to have that bargain for exchange. You have to have that quid pro quo. Excuse me. Now, the next problem area with regard to consideration is pre-existing duty. And we've talked about how a promise to do something or doing something that you're not already obligated to do is perfectly good consideration. So let's look at a couple of examples of where that can become a problem. With regard to pre-existing duty, if you have a pre-existing duty to do something, that can't form the basis of new consideration. In other words, if all of y'all in the class got together and said, hey, we really appreciate your efforts, Richie, in teaching this class online and making a YouTube channel, we've all agreed to chip in and we're going to give you $5,000. Now, the question becomes, is that promise supported by good and valuable consideration? And the answer is no. And the reason for that is I have a pre-existing duty to teach this class. In other words, I'm under contract with the college. They pay me X amount of money, and I teach the class. I'm obligated under my contract with the college to teach this class. So when you guys get together and say, hey, we really appreciate you doing this, we're going to give you $5,000 for teaching this class, that's not good consideration. Again, because I'm already obligated to teach the class. Another example would be a state trooper is assigned to investigate kidnapping of a child. And the parents of the child offer $1 million reward for the safe return of their child. And the trooper is able to safely rescue the child and return the child to their parents. And the trooper says, hey, I've got your kid back. Thank God. This is great. I'll take that $1 million now, please. And under contractual principles, the trooper would not be entitled to the $1 million because the trooper has a pre-existing duty as part of their job of being a state trooper to find the child and return the child home safely. So another example of past consideration. Now, sometimes we run into this problem in the area of construction contracts. So you contract with a home builder to build you a new home for $1 million. Sign a contract that calls for all the things, all the costs, everything associated with the construction of your new home under this contract. And 3 months into the build, the contractor comes to you and says, hey, I'm going to need another $100,000 to finish this house. The question becomes, he has a pre-existing duty to build that house under the original contract price. And even if you agree to pay him an extra $100,000, the question becomes, is that good and valid consideration? Because again, under the original $1 million contract, the contractor has an obligation, a pre-existing duty to build that house. Now, that's assuming that there aren't any changes made to the contract. Obviously, if the people working with the contractor who are having a house built for them go to the contractor and say, hey, we want marble floors now, or we want to change this, or we want to change that, that will not be encompassed under that pre-existing duty because it wasn't part of the original contract. And therefore, with the change, you're going to have good and valuable consideration because there is no pre-existing duty there. Okay, so that's consideration in a nutshell. I want to talk a little bit now about capacity, the third element of a valid contract. Capacity refers to one's mental ability to enter into a contract, really mental ability to enter or to reach an agreement, to have a meeting of the minds. There are several problem areas with regard to one's capacity to enter into a contract. The first is if you are under the age of 18, if you are a minor. Minors cannot contract under most circumstances. In other words, you have to be 18 years of age to enter into a valid contract. The law presumes that you lack the mental capacity to enter into a contract when you're under the age of 18. So what happens if and when a minor enters into a contract? Now, there are three terms I want you guys to be familiar with when we talk about capacity. And those terms are as follows. Number one, valid. A valid contract can be enforced by both parties to the contract. So if it's a contract is valid, both parties can enforce it. If either party breaches that contract, they can sue. A contract that is voidable is a contract that one of the parties, as a result of some problem with capacity, can get out of if they so choose. So again, a voidable contract is one where one of the parties suffering from a lack of capacity, can get out of the contract if they so choose. So, a contract with a minor is voidable at the option of the minor. So, example, a minor enters into a lease agreement. So 17 and a half years old, signs a year-long lease. The landlord makes a mistake by agreeing to it. That lease becomes voidable at the minor's option. So even if it's a year-long lease, the minor can get out of it at any point, up and until they reach the age of 18. So let's say they're 17 and a half at the time they enter into the contract. So for the first 6 months of that contract, the minor has the option to get out of the contract if they so choose. The landlord doesn't. Again, it's voidable. Only one party can get out of it. But the minor can. Now, halfway through the lease, 6 months into a year-long lease, the minor turns 18. Now, at this point, they're no longer suffering from a lack of capacity. So, whenever a contract is voidable, the person who can get out of the contract, in this example, the minor, has an option once they turn 18 to either ratify the contract. Basically, when I say ratify the contract, meaning saying, hey, I was 17 when I entered into this contract, but I want to continue to be bound by its terms. And that can be done in an express fashion or an implied fashion. An express fashion was on your 18th birthday. On their 18th birthday, the minor calls up the landlord and says, hey, I turned 18 today, but I want to continue with the terms of my lease for the next 6 months, because remember, it was a year-long lease and we're 6 months into it. At that point, they've given an express ratification of the contract, and the contract, which was voidable at the minor's option, is now a perfectly valid contract enforceable by the other side, by both sides, I should say. That's an express ratification. You could also have an implied ratification. Now, how would an implied ratification work? It's not too complicated. I turn 18, I continue paying my lease payments. By continuing to pay my lease payments even after I turn 18, I've ratified that contract. In other words, I've let the landlord know in an implied fashion that I want to be bound by the terms of the contract. Now, I haven't called him up and said, hey, I ratify, or hey, I want to continue abiding by this lease even after I've turned 18. But by continuing to make those lease payments, the tenant has ratified the contract in an implied manner. And we have a valid contract. Now, one more term that I forgot to give you is if a contract is just straight up void, not voidable, but straight up void, then neither one of the parties to the contract can enforce it. And we'll get to a couple of situations where that's where a contract is void. Most of the contracts that people with capacity issues enter into end up being voidable. But again, I'll give you an example here in a minute of a contract that is just straight up void. Okay. So the next problem area with regard to capacity is mental illness or senility, say with an older person who's losing some of their cognitive abilities. If you enter into a contract with somebody who has a mental illness, under many circumstances, and obviously it depends on what kind of mental illness we're talking about, and really mental illness might not be the best way to say it, but some condition which renders either permanently or temporarily that person to lack the capacity to have to be able to enter into a contract, to be able to come to an agreement, to be able to understand what's really going on. And a person who enters into a contract while laboring under a mental illness or senility as a result of old age or any reason, that contract is then voidable at that person's option, just like a contract, just like a minor entering into a contract, the contract becomes voidable. Now, just because you're mentally ill doesn't mean you can't enter into a contract. You could obviously have a mental illness and still have your wits about you and be able to enter into an agreement and understand what's going on, have a meeting of the minds with regard to the agreement. So, and I'm sure all of us, myself included, have a loved one or a good friend that suffers from a mental illness, or a grandparent or some relative who has a decline in their cognitive abilities as a result of age. So, just because you're old or just because you have a mental illness doesn't mean you can't enter into a contract. But if it turns out that that person lacked capacity, in other words, they couldn't understand what's going on, then it's voidable and they have a right to get out of it. So, for example, I have a relative who suffers from bipolar disorder. And the overwhelming majority of the time, this person is fine, has their wits about them, knows what's going on, and no question in my mind that they have the mental ability to reach an agreement and enter into a contract. But periodically, this person, this loved one, will stop taking their medication. And it's usually because, hey, I feel great. I really don't need to take this medication anymore. The side effects aren't great. And they stop taking their medication. And what typically happens is they go downhill and are seriously affected by their illness. During these periods, my relative clearly would not be able to enter into a contract. And if they entered into a contract, that contract would be voidable at their option. So they do something that's not good for them. They agree to sell all their real estate for $100 when it's worth $1 million. Obviously, their lack of capacity will allow them to get out of that contract. Again, it's voidable, so they can get out of it. But let's say that after a period of a month or so, they go back on their medication and they're fine again. At that point, just like the minor who turned 18, they can ratify or disaffirm that contract. So back on my meds, feeling good. I can do an express ratification. I can do an implied ratification. If I'm supposed to make payments on something, for example, if I call them up and say, hey, I didn't really know what I was getting myself into. I was off my meds, but this is a good contract for me and I want to continue abiding by its terms, that would be an express ratification. An implied ratification would be just like continuing to pay your rent. If that person continues to perform, to do what they're supposed to do under the terms of the contract, then that would be an implied ratification. So they can get out of it, but if they choose not to, and when they get out of it, that's called a disaffirmance. So anytime you have a voidable contract, you can disaffirm. So when the minor turns 18, and I can't remember whether I mentioned this or not, they can call up, I forgot what the example was. They can call up their landlord under the lease and say, hey, I want to get out of this contract. And that's called a disaffirmance. So anytime you have a voidable contract, you need to look for ratification or disaffirmance. So in the mental illness example, I'm get back on my meds, I'm fine. I can ratify that contract either by expressly doing it, by calling them up, and again, I'm repeating myself, but saying, hey, I want to be bound by the terms of this contract. Or I can disaffirm. I can say, I didn't really know what was going on when I entered into this contract. I want out of it. I'm done. And again, that can be you can ratify expressly or in an implied fashion. Now, another example would be an older person suffering from a cognitive decline. And if you have a relative, a grandparent or something that's suffering from some type of age-related cognitive decline, in my experience, you could show up one day to grandma's house and grandma will be like, hey, Richie, how you doing? Hey, your birthday's next week. Talk to me about current events. Totally fine. And then I go to see her the next day and she doesn't know who I am. That's a tough thing, but that's a good example of lacking the capacity to enter into a contract and having it be voidable. When you get into these issues of whether or not the person had the capacity to enter into the contract because of mental illness or old age or some type of cognitive decline, typically what you're going to see is some testimony from that person's treating physicians or people that are close to them who've observed them for a period of time to testify in court about what their condition was. So if you have the person's treating doctor who comes into court and says, hey, I've been treating Mr. Johnson for over a year now, and there's no way he had the capacity to enter into a contract or sign a deed, which is like a contract but a little bit different. And you see those problems a lot with regard to older people signing over their property, perhaps to a relative who the other relatives don't think is appropriate. And then you have a court fight about whether grandma had the capacity to sign over her land or enter into a contract. So you typically see expert testimony on whether or not a particular person has the capacity to enter into a contract. Now, with regard to mental illness or old age or cognitive decline, whatever you want to call it, there is a situation where that person becomes completely unable to enter into a contract. And if they do, that contract is void. Now, the only time the contract is void is when a court has adjudicated somebody incompetent. In other words, a court has made a finding that this particular person is incompetent. And that happens pretty much exclusively through a guardian and conservator case. And I don't want to get too much into guardian and conservator cases, but suffice it to say that let's say you have a grandparent who can't take care of their own affairs anymore, doesn't really know what's going on, and you or another family member or a friend petition the court to allow you to take over their affairs. A guardianship allows you to take over their everyday life decisions, where they're going to live, what they're going to do, etc. And a conservator, and they're usually together, but a conservator handles all their financial affairs. So let's say my grandfather can't take care of himself anymore. I file a petition with the court saying I would like to become my grandfather's guardian and conservative so I can take care of him, handle his financial affairs, and handle his everyday life affairs. I file that petition with the court. The court will appoint my grandfather an attorney, and we will arrange for a doctor or a psychiatrist. Well, doctors are psychiatrists. A psychologist, psychiatrist, some other expert to take a look at my grandparent and give the court an opinion on whether or not my grandparent is competent to handle their own affairs. We have a hearing. It can be contested. Again, an attorney is appointed to represent. We call him a protected person, an alleged protected person, my grandfather. But if the court decides, yes, grandpa can't take care of his own affairs and also decides that I'm an appropriate person to take over their affairs, then my grandfather has been adjudicated incompetent. And at that point, my grandfather cannot enter into contracts anymore. And if my grandfather does enter into a contract, it is void. Neither my grandfather or the person with whom he's contracted can enforce that contract. It is void. Neither side can enforce. Again, contrast that with a voidable contract where only one party can get out of the contract. So, if the person has been adjudicated by a court of law as incompetent, the contract is void. Now, I'm the guardian and conservator. I can enter into contracts on behalf of my grandfather, but my grandfather himself cannot. And there's a bunch of other restrictions on that are important to what we're talking about today. Okay, we're at about a half hour, but I want to get through the one last problem area with regard to capacity, and that is intoxication. A person who is intoxicated to the point where they can't reach an agreement, they can't come to an understanding of what the contract is all about, then that contract becomes voidable at the person who was intoxicated. It becomes voidable at their option. So again, we're looking for a ratification or a disaffirmance. Now, when can a person who is intoxicated ratify or disaffirm a contract? When they're no longer intoxicated, when they've sobered up. So the example that I would give you is I go to a party, I have too much to drink, I'm heavily intoxicated, and while in that intoxicated state, I call up the local beer distributor and I say, hey, I've decided to have a big party tomorrow and I want 20 kegs of beer delivered to my house by 9 a.m. Beer distributor says, great. Excuse me. Beer distributor says, great. We can get you those 20 kegs of beer. It's going to cost you $500 and it's payable when we deliver the kegs. No exceptions. And I say, great. We'll see you tomorrow. Again, I'm intoxicated while I do this. I wake up the next morning, not feeling great, but I'm no longer intoxicated. Friend comes in and says, hey man, can't wait for the party today. I'm like, oh, what the heck? I don't want to have a party today, and I don't have $500 to pay for 20 kegs of beer. So at that point, because I'm no longer intoxicated, I have a right to disaffirm the contract because it's voidable due to my intoxication. So I can call up the beer distributor and say, hey, I was intoxicated last night. I didn't know what I was doing. I don't want the 20 kegs of beer. I disaffirm the contract that we've made. Or if I still want to have the party, I can call them up and say, hey, I was really drunk last night, but I still want the 20 kegs of beer, and I'm ratifying the contract. That would be, again, an example of an implied ratification. Or excuse me, sorry, an express ratification. I don't want to be bound by the terms of the contract anymore. Now, I can do an implied ratification too. I wake up the next morning, I'm perfectly sober, and I call them up and I say, hey, I ordered 20 kegs of beer yesterday. I'd like 400 plastic cups too. By calling them up after I'm not intoxicated anymore and adding to my order, that would be an express ratification of the contract. In other words, I'm not intoxicated anymore, but I'm indicating to them that I want to be bound by the contract because, again, I was intoxicated and it was voidable at my option. So those are the three problem areas with regard to capacity. Minority, under the age of 18, mental incompetence, again, remember, void and voidable, and intoxication. Remember, ratification and disaffirmance. Anytime you see a contract that is voidable. And these questions are really easy to ask in a multiple choice fashion, so I would expect to see those on your test. All right, that's enough of me talking for now. Let's briefly, I've had some inquiries from students about final exam and tests like that. I'm going to come up with a couple of assignments to give you guys. They won't be too difficult. They'll just be designed to reinforce the lectures, and I'll have those to you hopefully by the end of the week. And then my plan is to just have a final exam. And so we'll get through contracts and we'll get through business organizations. And if we have extra time, there's plenty of subject matter to fill those areas. Again, I hope this video comes out okay. If you have any questions whatsoever, please don't hesitate to call me, email me, or text me. Leave me a comment in the comments section to let me know that you've viewed the lecture. Again, you don't need to view this until Wednesday, but I just had an opportunity here on my lunch break at work to go ahead and make the video. So again, don't stress. We're all going to get through this together. You're all going to do fine. I'm trying to make these videos a little bit more exciting as we get along, but the subject matter is dry, but I'll do the best that I can. All right, I don't think I have anything else. I hope to hear from you guys. Again, just shoot me a comment one way or another. And thanks again. I hope you all are doing well. I'm doing fine. I know I got an email from the college today that they're going to what they call the level 2 thing where everybody's going to work from home. Because of my job in the prosecuting attorney's office, I've got to continue to come to work because the Constitution doesn't get suspended. People have constitutional rights that have to be abided by. They have to have hearings in certain types of cases. We can't just let people sit in jail indefinitely. We're also working to try and get some of the people out of the jail that are nonviolent, things like that. I'm sure you've read about those situations in the newspaper. But I am available to you at any time. So I will have another lecture posted here in the next couple days. Thanks, guys. Appreciate you tuning in, and God bless you.